So the Medical Marijuana Act was an initiative that was drafted by an organization called the Marijuana Policy Project. We have been struggling with the Medical Marijuana Act for the last 5 years because it was so poorly written. The Marijuana Policy Project, who also is the organization responsible for the criminal law legalization initiative, did invite the participation of activist organizations and attorneys in helping them to draft the provisions for their proposed 2016 legalization initiative. In fact, Safer Arizona paid the MPP $1,000 to be a part of what they referred to as the stakeholders, which was supposed to give you a seat at the table to have an influence on how the initiative would ultimately be drafted. We were never invited to a single meeting. I can just tell you, the Safer Arizona designated me to represent them in these meetings, and I was never invited. I was never at any table. The only work that we were able to do was by simply, emailing and calling them directly and urging them to accept what we believed were essential provisions to any legalization, any meaningful legalization initiative. In fairness, I'll say that we made progress. Because of our efforts, we have, for example, home cultivation, which the MPP had removed as a provision in the Legalization Act. There are good dispensaries out there and good dispensary owners who do support the consumer interest. But there were a number of wealthier dispensaries out there who had donated a large amount of money to the MPP's campaign, and they were against home cultivation. They would rather that patients have no choice but to come to them. Patients, in this case adults over the age of 21, have no option but to come to them to purchase cannabis, and would rather they not have the ability to produce it themselves. So they were against that. We were able to determine which dispensaries those were, and published that. In response to the boycott, I got many phone calls here, everything from please, whatever I have to do publicly, take me off of that list, to I'm going to sue. Ultimately, though, what happened was that they capitulated, and the MPP agreed to include home cultivation. What they refused to do, though, is to include a defelonization of a mid to what we call a mid-tier of nonviolent cannabis offenses. By defelonization of a mid-tier of offenses, what I mean is that, for example, while they did agree to allow the home cultivation of 6 plants, if someone had, say, were within their legal limit of 6 plants, and those plants were mature, but then they had a clone that was also growing, then that would be a 7th plant, and that individual would lose all the protections afforded under the criminal law initiative, and likely the combined weight of those plants would exceed 2 pounds, which would mean that person would be facing mandatory incarceration in prison under Arizona law. And if the total weight was more than 4 pounds, which it very likely would be, that mandatory prison sentence would be between 4 and 10 years for a first-time offense. We felt that was maybe unreasonable. What we see law enforcement will do is they'll go into a lawful medical marijuana grow and say, you're within your plant limitations. You're not in violation of the Medical Marijuana Act as far as the number of plants that you're allowed to cultivate, and you're authorized to do so. However, we believe, in our opinion, that you're growing too much. You're producing too much than you need. And so, without any direct evidence of it, we're going to accuse you of the possession of marijuana with the intent to sell it on the black market, so-called. to divert that onto the illicit market with no direct evidence. And this is a fact. And there are many people who have been present at hearings that I've been had in court who know exactly what I'm talking about. This is not a theory, this is a reality. So the issue is, what if law enforcement determines that, in their subjective opinion, a person's 6 plants are producing more marijuana than they really need for their own personal use? Well, that means that without any direct evidence, they're going to allege, as they have in the context of medical marijuana grows, that that person is in possession of marijuana with the intent to sell illegally. And that person will, like, if it's more than 2 pounds, be facing mandatory imprisonment. I can tell you that cannabis consumers and people who grow cannabis are not criminally minded persons. These are regular, ordinary persons. Many of them very successful, very brilliant, very healthy, very persons who are of value to society, no question about it. The idea of going to prison was never anything that most cannabis consumers ever thought could be a reality. This was never on their radar. And so when suddenly facing 4 to 10 years of mandatory prison, because the government is alleging, yes, you could legally grow marijuana, but we think you grew too much for your own use. And when there's an option of taking probation on a deal, on a plea deal, I don't care if I'm telling them that I'm 95 or 97% sure that we will win this case. That 3 or 5% chance that they could go to prison for 4 to 10 years, in the overwhelming majority of cases, most people will say, look, I can't even take any chance. I can't go to prison. And they end up taking a deal. And they plead guilty to an offense that they were not guilty of. And have to undergo the humiliation of being put on probation. So we expect that the same pattern will carry over into recreational, where a person can grow 6 plants. But if you grow and if you grow too much, for this detective and in this detective's opinion, and we think that that's more than you need, then based on that, we will go to a grand jury. And many people have heard the saying that you can indict a ham and cheese sandwich. I mean, a prosecutor can get a grand jury to indict on anything. There's no judge. There's no defense attorney. There's no defendant. It's just the prosecutor and the grand jury. And the prosecutor tells them what he or she wants them to do. So getting an indictment is a farce, really. And every criminal defense lawyer and every prosecutor out there knows that. So they'll get an indictment against that person because they'll have their cop stand up there, their detective, and say, oh, yes, I've an experienced narcotics officer, and in my opinion, this amount of marijuana that they were producing, okay, yes, they were within their legal limit of plants under the law, but the amount of marijuana that those plants were producing, this was not consistent with personal use, and in my opinion, was large enough to means that they were going to sell this illegally. And the grand jury will say, wow, thank you. Not having the opportunity to hear from anyone on the defense's side, will indict that individual, and they'll be facing mandatory prison. That is going to happen under the MPP's legalization initiative, and I'm not trying to say that. I think that, in fairness, the MPP probably didn't even consider this possibility. But this is why it's critical that in 2018. Regardless of whether or not the MPP's initiative passes in 2016, that we pass an initiative that corrects a lot of these deficiencies. Whether it's a new initiative because the MPP's initiative doesn't pass, or whether it's a corrective initiative because we have the MPP's initiative, but there's so many problems, some of which we've discussed, that need to be corrected. Either way, we need to pass an initiative in 2018.